When Shaquille O'Neal walked into courtroom 14B of the Richard B. Russell Federal Building in Atlanta, Georgia, on a Monday morning in October, he sat in the gallery the way anyone sits in a federal courtroom gallery, quietly, without drawing attention to himself, in the third row on the left side behind the plaintiff's table. He was wearing a dark suit, a white shirt, no tie. The chain was at his collar, small and gold, a crucifix on a thin rope, the one thing on him that was not chosen for the occasion. He had his hands in his lap, and he was reading a document that his attorney had given him that morning, and he was reading it the way he read things that mattered, slowly, with the full attention of a man who has learned that the details are the thing, and not the summary of the thing. The case was Meridian Housing Alliance versus Coastal Development Group. The Meridian Housing Alliance was a non-profit that had been building affordable housing units in underserved Atlanta neighborhoods for 11 years. Shaq's foundation had been its primary funder for 7 of those 11 years. Coastal Development Group was a private developer that had, over the course of 18 months, acquired parcels adjacent to 3 of Meridian's completed developments, and had then pursued a series of legal actions designed to challenge Meridian's zoning compliance. Actions that had, if successful, have resulted in the displacement of 412 families currently living in those units. Shaq was in the courtroom as the named representative of the foundation, a legal designation that gave him standing in the proceedings and the right to be present at all sessions. He had been told this by Maya Chen, his lead attorney, who had also told him to sit in the third row and read the document and let her do the talking. He was reading, he was sitting, he was, by every measure available, doing exactly what he was supposed to be doing. The judge entered at 9:02. His name was Harold Pressler, 63 years old, federal bench for 14 years. He was a compact man with the specific authority of someone who has occupied a position of institutional power long enough that the position and the person have become difficult to separate. He took his seat. The courtroom settled. The clerk called the case. Pressler looked at the plaintiff's table. He looked at the defense table. Then his eyes moved to the gallery and stopped. They stopped at the third row on the left side. He looked at Shaq for a moment with the expression of a man who has encountered something in a room that he has decided is not appropriate to the room. Then he said from the bench, without preliminary, "Who is that individual in the third row?" Maya Chen was already on her feet. "Your Honor, that is Shaquille O'Neal, the named foundation representative of the plaintiff, and a designated observer for these proceedings. He has full standing to be present under Federal Rule of Civil Procedure 43. Pressler looked at her. Then he looked at Shaq again. "This is a federal courtroom," he said. "It is not a publicity event. The presence of high-profile individuals in the gallery creates a distraction that this court will not accommodate. I'm going to ask that individual to remove himself." The courtroom was very still. Shaq did not move. He looked at the judge the way he looked at everything that required stillness, with his full attention and without the reaction the room was waiting for. He kept his hands in his lap. He kept the document where it was. He looked at Harold Pressler from the third row with the specific, patient quality of a man who has been in enough rooms that have told him to leave that he has developed a very precise understanding of when to leave and when to stay. This was a when to stay. He stayed. Maya Chen said, "Your Honor, respectfully, Mr. O'Neal's presence is legally designated and documented with the court. Removing him would constitute interference with the plaintiff's right to representation. I would ask that the court identify the specific legal basis for the removal request before any action is taken." Pressler's face did something. Not anger, the specific tightening of a man who has asked for a thing in a room where he is accustomed to receiving what he asks for and has not received it. "Counsel," he said, I will not be questioned from the floor of my courtroom." "You are not being questioned, Your Honor," Maya said. Her voice was completely level. She had not raised it by a single degree since she stood up, which was the most precise and disciplined thing happening in the courtroom at that moment, and everyone present understood this. "You are being asked to cite the legal basis for a removal that would affect my client's rights. That is not a question. It is a procedural requirement." Pressler looked at her. He looked at Shaq. He said, "Remove him, or I will have the marshals do it." Maya said, "Your Honor, before that order is executed, I need to place something on the record." She reached to the table. She lifted a bound document. She said, "The plaintiff moves for the recusal of the presiding judge in this matter under 28 U.S.C. Section 455, on the grounds of a conflict of interest that was not disclosed at the commencement of these proceedings." She paused. One beat. Completely still. "Your Honor, that motion has already been filed." The courtroom did not make a sound, but here is what Harold Pressler did not know had been building for 3 weeks, and what nobody in that gallery understood yet about the woman standing at the plaintiff's table holding a bound document with both hands and no expression on her face whatsoever. Maya Chen had been Shaq's lead attorney for 4 years. She was 41 years old, the daughter of a Taiwanese immigrant father who had driven a delivery truck in Houston for 22 years, and had never once in those 22 years been late, and had never once asked for anything he had not earned, and had passed to Maya a work ethic so structural it had become indistinguishable from her character. Her mother was from Louisiana, black, the daughter of sharecroppers 2 generations removed, and had put herself through nursing school while raising 2 children with the specific ferocity of a woman who understands that the system was not designed for her and has therefore decided to master the system with a precision it did not anticipate. Maya had inherited both, the patience of her father and the ferocity of her mother, and had organized them into something the law could use. She had graduated top of her class at Emory Law and had been told by 2 partners at 2 separate firms during her 3rd year that she was impressive, but perhaps better suited for a different kind of practice. She had understood what kind of different they meant. She had filed those assessments in the same place she filed all incorrect information. Nowhere useful. She had clerked for a federal judge in the 5th Circuit. She had spent 8 years in civil litigation at a firm in Atlanta before going independent. She had taken Shaq's foundation work because she believed in what the foundation was building and because she was the kind of attorney who needed to believe in the thing, or she could not do the thing at its full capacity. She had been watching Harold Pressler for 6 weeks, since the case had been assigned to his docket, with the specific attention of a woman who had sat behind a federal judge for a year and knew what judicial conduct looked like when it was clean, and knew, with equal clarity, what it looked like when something else was running underneath the surface of the clean. What was running underneath it was this. The lead attorney for Coastal Development Group, the opposing counsel, the man on the other side of this case, was a partner at a firm called Hargrove and Weil. His name was Stephen Hargrove, and Stephen Hargrove had been Harold Pressler's law partner for 11 years, from 1989 to 2000, before Pressler had taken the bench. They had built a firm together. They had tried cases together. They had, according to bar records Maya had pulled and cross-referenced with 3 separate sources, maintained a relationship that included attendance at each other's family events as recently as 18 months ago. Under 28 U.S.C. Section 455, a federal judge is required to recuse himself from any proceeding in which his impartiality might reasonably be questioned. Pressler had not recused himself. He had not disclosed the relationship. He had accepted the assignment and had presided over 6 weeks of preliminary proceedings without a word. Maya had been building the recusal motion for 3 weeks. She had been waiting for the moment to file it. not filing it prematurely, because a premature filing gives the opposing party time to prepare a counter-argument and gives the judge time to manage the narrative of his own removal. She had been waiting for the moment when filing it would be most effective, most documented, most clearly in response to conduct that the record would show. She had not manufactured the moment, she had simply been ready when it arrived. Harold Pressler had handed her the moment from the bench at 9:04 in the morning by trying to remove a man from a courtroom for no legal reason, in front of a full gallery, on the record. There are things you have to understand about Shaquille O'Neal before you understand why he was in that courtroom and what it cost him to sit still in the third row while a judge told him to leave. He had been told to leave rooms before, rooms that were louder about it and rooms that were quieter, rooms that used policy and rooms that used assumption, and rooms that used the specific authority of someone positioned above him in the immediate geography of a moment. He had sat on benches and stood on sidewalks and ridden in cars and waited on curbs, and each time had carried the same thing his mother had given him, which was not patience exactly. Patience implies tolerance, and what his mother had given him was not tolerance, but the specific understanding that a room's verdict about you is not the measurement. The work is. The presence is. The standing in the room when the room tells you to leave, legally, with standing, with every right that the room itself provides. That is also the work. Lucille O'Neal had known about rooms. She had lived in Newark long enough to know that rooms have owners, and that the owners are not always visible, and that the invisible ownership expresses itself in 100 small ways before it expresses itself in the large one. She had known about the law as a room specifically, had talked about it once, sitting at the kitchen table when Shaq was young, and something had happened in their neighborhood that had made the law visible in the way that the law sometimes becomes visible in certain neighborhoods. Suddenly, without gentleness, in a form that made clear the distance between what the law said and what the law did. She had sat with him at the table, and she had not told him the law was fair, because she was not a woman who told her son things that were not true. She had said, "The law is a room too, and you belong in every room you walk into, not because someone said you could, because you built the standing to be there, and standing does not require permission once it is established." She had paused. She had looked at him with the specific directness she reserved for sentences she was handing him to carry for the rest of his life. They will try to tell you the room is not for you. That is not information about the room. It is information about them. The room is yours when you have the standing for it. Your job is to have the standing. Let them deal with what that means. She had pressed the chain into his hand that same afternoon. She did that sometimes, the pressing of it, when the conversation had been about something that needed to be held. Small, gold, crucifix on a thin rope. You carry this, and you remember that you stay. Sarge had given him the operational half of it. Sarge had understood from the military that the most powerful response to an unlawful order is not defiance. It is procedure. Not noise, not volume, not the performance of resistance. The correct invocation of the correct rule at the correct moment, delivered without emotion, in the language the system itself uses, which removes from the opposing party any ability to characterize your response as anything other than what it is, correct. He had told Shaq, "In a system, the system's own rules are your most powerful weapon. Learn them better than the people who think they own them, and then let the rules do the work so you don't have to." Maya Chen had learned them better. She had spent 14 years learning them better. She was demonstrating this now, standing at the plaintiff's table with 61 pages in her hands and no expression on her face, and her voice at the exact same level it had been when she stood up. The recusal motion landed on the record at 9:07 on a Monday morning in October. It was 61 pages. It included bar records, event attendance documentation cross-referenced with social media and court calendars, a timeline of the Hargrove-Pressler relationship, and a specific accounting of the 6 weeks of preliminary proceedings during which the undisclosed relationship had existed. It had been prepared by 2 associates and reviewed by a former federal clerk who had worked under Section 455 cases for 12 years. It was not a document that could be quickly answered. Pressler looked at it. He looked at Maya. He looked at Shaq in the 3rd row, still in his seat, hands still in his lap, document still where it had been, chain catching the courtroom light. He said nothing for 8 seconds, which is a long time to say nothing when you are a federal judge on a bench in a full courtroom. Then he said to his clerk, "We'll recess." He stood. He left the bench. He did not look at the gallery again. The recess lasted 4 hours. When proceedings resumed, it was under a different judge, the Honorable Patricia Osei Bonsu, appointed to the case on emergency reassignment. She opened by acknowledging the recusal motion, confirming it had been accepted by the court administrative office, and stating that the record of the morning's proceedings would be preserved in full. She looked at the plaintiff's table. She looked at the defense table. She said, "We will begin." Maya sat down. She looked at Shaq. He looked at her. She said nothing. He said nothing. There was nothing that required saying. The document was on the record. The judge was gone. The room was what it was now, which was different from what it had been at 9:04, and both of them understood that difference without needing to describe it. The case proceeded for 11 more weeks. Meridian Housing Alliance prevailed on all primary counts. Coastal Development Group's zoning challenges were denied. The 412 families in those 3 developments stayed in their homes. The judgment was not appealed. Harold Pressler received a formal inquiry from the Judicial Council of the 11th Circuit 6 weeks after the recusal. The inquiry took 4 months. Its findings were not public record. What was public record was that Pressler took senior status, a form of semi-retirement from full judicial duties, the following spring, citing personal reasons. Stephen Hargrove's firm settled a separate bar complaint filed by Maya Chen's office 14 months later. The terms were not disclosed. Maya Chen billed 40 hours to the recusal motion. She did not charge the foundation for them. She marked them in her ledger as pro bono, 2 words, no explanation, and closed the file and opened the next one. Shaq sat in the 3rd row for the duration of the 11-week trial. He read his documents. He listened. He did not speak in the courtroom except when called upon to do so. He came in every morning in the dark suit and the white shirt and the chain, and he sat down, and he stayed. His mother had said, "The law is a room too." She had said, "You belong in every room you walk into." She had said, "They will try to tell you the room is not for you, and that is not information about the room." He had stayed. He had let Maya do what Maya did. He had let the motion land at 9:07 and the recess happen and the judge leave the bench and the new judge take over and the 11 weeks proceed and the 412 families stay in their homes. He had stayed. That was the work. That was always the work. And the room, in the end, had confirmed it, not because he had needed the confirmation, but because the room had its own rules, and the rules had been learned correctly, and when the moment came, the moment had been ready. Drop a comment right now and tell us, where are you watching from, and has a room ever tried to remove you from a space you had every right to occupy? This story deserves a like if you believe that the most powerful thing you can do when a room tells you to leave is know you're standing, stay in your seat, and let the right person file the right motion at the right moment. And if you believe that 412 families staying in their homes is what justice actually looks like, subscribe. This community is built on that belief. The next video is already there. We will see you there.